So good afternoon. My name is Ann Mangiamelli, and I'm the managing attorney of the Health Education and Law Project, or HELP, over at Legal Aid of Nebraska. I said I would introduce myself because I'm usually okay with I'm Ann, I'm a lawyer, but I thought I'd give you a little bit of background. So the HELP project at Legal Aid, we collaborate with hospitals to help patients anything that we see as a health inhibitor or something that's getting in the way of them being healthy. Or something that is inhibiting their access to health. So, I mean, always the easiest to talk about is Social Security and Medicaid is one thing that oftentimes will keep individuals from being able to obtain medical care. And I've got Social Security on here, but I've also got Medicaid at the end that I'll talk a little bit about as well. I like to do these in an interactive fashion. I don't like people waiting till the end to ask questions because oftentimes I find if you have a question, somebody else probably has that same question. And then once we get to the end, if you're like me, you're thinking, gosh darn it, I had a question. What was it? I don't remember. So if I'm talking and you come up with a question, please raise your hand and ask the question then so I can address it. So I make sure that I answer everything that you guys have as questions. The other thing that I always tell people is I am not giving this session because I want you to know the law. What I want you to do is have a basic understanding so that you can spot a legal issue when a client has it. And if you're a hospital that has a collaboration with us, you can then do a referral over to our to HELP. If you are not a hospital that has a collaboration with us, then you can send them to our access line. Unfortunately, our access line, which is regular legal aid, doesn't cover all of the kinds of cases that the HELP project does. But hopefully they can get some sort of help. So I will start. So there are two different kinds of disability. And when patients are talking about disability, they will just say disability. But there's actually two different kinds that they can apply for. And some of them, they're similar in some ways, but then different in others. So what a client or a patient might be eligible for is going to change depending upon what their situation is. So SSI, or Supplemental Security Income, is a federal program that is for individuals 65 or older, blind, disabled children or adults. The big thing to know about this is an income-based sort of benefit. Your patients, you're mostly going to be talking about patients that have a disability that are going to qualify for this. The other kind of person that you might run into that's going to qualify for this is someone who is 65 or older and not getting a very big retirement benefit. So you have to have a certain amount of under income and assets to qualify for supplemental security income. You either have to be, I'm not going to go into the blind, but disabled or over 65. You have to have less than $2,000 in assets. They do not count a car and they don't count your house if you're living in it. But disability is the big thing that you're going to be dealing with most of your patients. The income, and it's in 2017 it was $235. It is now, I believe, $270 is what they will get if they are eligible for this benefit. The big thing to know about this benefit is if a patient qualifies and is found disabled for SSI benefits, they automatically in this state qualify for Medicaid. They still have to do the Medicaid application, but they will then meet all of the qualifications for Medicaid. So as long as they qualify for this, they should be able to qualify for Medicaid in this state as well. Okay.
And that's in addition to Social Security income?
So possibly not. I'll get to the Social Security income and then tell you how somebody can be dually eligible for that. Did that not go? Oh, here we go. So blind, I don't know if I want to get into. And you guys are going to get these slides. I hate PowerPoint. I'm just going to tell you right now. So this goes into a little bit of the income, the two sort of categories that you can qualify for SSI. One of them is going to be that you have under a certain amount of money, and this is where people get into you can't be working. I'm going to get to the interesting. These are the things that I said don't count as income. If they're getting SNAP, that's not going to count as income. If they live in a house, that's not going to count as income. Same as Medicaid. The earned income tax credit doesn't count against it. But the big thing to know about the SSI is it is if you've not paid into insurance system. So when you guys are working and you pay FICA, that does not go in for this. This is meant for people that have not worked enough to be what's called fully insured once they're found disabled. Okay, let me go to this and then I'll go over and then I'll go back to those other slides. So the second program that I said that there is SSDI, or Social Security Disability Insurance. This kind of insurance is for individuals who have paid in. So say that you are an individual who is 40 years old and you have worked for the last 10 years and suddenly you become disabled. You are going to qualify, if the court finds you disabled, for SSDI. The big difference in the scheme of things is you get more money. So folks that have paid in to SSDI and qualify under that benefit aren't going to get that $770. They're going to get money every month dependent upon how much they've paid in over the period of time that they've worked. The way that you can be dually eligible, so you can qualify for both SSDI and SSI, is if, say you've worked, but you worked a job where you did minimum wage. So you didn't make very much. So you weren't paying in very much. So when they figure out your benefit under SSDI, they say, well, yeah, you're disabled. All we can pay you under SSDI is $400 a month because that's really all the benefit that you've paid in. You could then qualify for SSI for that other amount up to $770. So in that instance, you would be dually eligible. You would get $400 in SSDI and another $370. See how I'm a lawyer, but I still did math fast. That's why I always use round numbers. So then you would get $370 in SSI payments. Again, under that, you would still qualify for Medicaid. The big thing about SSDI, besides the fact that if you've paid in and you qualify for that amount, after 29 months of being on SSDI, you also will then qualify for Medicare. You cannot qualify for Medicare if you are only eligible for SSI. So that is the big thing about why people want to be qualified for SSDI and not just SSI, is because then they can qualify for Medicare as well. And as you know, you can be duly qualified for Medicare and Medicaid, which I'll get into a little bit later. So
how many months?
So here's the weird thing, 29 months, and people are always confused by that. The reason it's 29 months is the way that Medicare works with somebody who's disabled and qualifies for this is they say, and this is what often confuses patients, is they say you are qualified for Medicare 24 months after you are in pay status for SSDI. There is a 5-month waiting period to get paid under SSDI. So say you're found disabled under just SSDI, that's all you applied for, January of 2019. So they find that you are disabled as of January of 2019. You aren't going to get paid under SSDI until June 1st. So that 5 months of waiting period, the first time you're going to see any money under that is going to be June 1st. You then qualify for Medicare 24 months after that, which is where I get the 29 months. It's the 5-month waiting period plus 24 months. I'll tell you my frustration with this. Individuals who, so as I said, if you qualify for SSI, you qualify for Medicaid. A lot of times these individuals who qualify for SSDI won't qualify for Medicaid because they have too many assets. So if you have over $2,000 in assets and you're a single person, you're not going to qualify for Medicaid or SSI. So I have individuals who are cancer patients who qualify for SSDI but won't get insurance under Medicare for 29 months. So I've had patients who actually have passed away still working because that was the only way they were able to get insurance.
Would you be able to show that the person was disabled before the time frame that you're talking about? Like they've been disabled for a period of time and now they're moving towards SSDI?
So that's a good question. So that is another difference between SSI and SSDI. SSI, if I apply for benefits and say I am disabled as of, say you really felt crappy for the last 15 months, but you didn't get diagnosed really until January 1st of 2019. But you had all of these symptoms that really you couldn't work prior to that. You apply for SSI benefits on January 1st. By law, they can't pay you prior to January 1st under SSI. Under SSDI, they can actually pay you 17 months prior to your application. So if you can show, so you file in January, and this is going to make me do math, which I won't do, but you'll figure out the months. So if you actually apply on January 1st under SSDI because you've paid in, and say, and your medical records prove that you really were disabled 17 months prior to that, that is your date of disability, and then you only have those months to wait before you would qualify for Medicare. So that is a good question, and it is sometimes, so that's why we are always very aware of when we can first prove when somebody was disabled, because then we can get the furthest back date possible if they're under SSDI. The other thing with SSDI is if you have somebody, and it's kind of a double-edged sword, if you have somebody, you have to be in a pay status. You have to have paid in a number of quarters. It's basically 10 years worth of work that you have to do before you qualify for SSDI. If you have folks but you run out of insurance. So if you don't work for a long period of time because you've been ill, you actually can fall out of insured status and then only qualify for SSI. And we have that happen quite often, and that's another time when we have to figure out, we know for sure this is the date we have to prove that they were disabled prior to that time in order to get them qualified for SSDI.
Would payments still not start then until 5 months after the January?
No. So if you were, again, under that same scenario, if you were found disabled 17 months prior, they would be, you would go the 17 months from that day, or the 5 months from that date, and so you would already be in pay status. But you reminded me of another point, which is, and I realize I have a PowerPoint, I hate them, so you guys hopefully are going to get a copy of these, but I'm very bad at working with them. So the deal with SSI and SSDI, when we have individuals who are poor and don't have, but they have enough to go into pay status under SSDI, we always have people apply for both programs. So I have individuals who they qualify for, and I will tell you that Social Security is not good at having people apply for both programs, and that's why I say if you can get them to come to my office and have us assist them with the application, it is very helpful for two reasons. Number one, we help them with that, what they call alleged onset date, the date they should allege that they actually became disabled, and that's important, and I'll go into that in a minute. That's important, one, for the insurance status, but there's another reason as well. So we will help them with that, but the other thing is we will get them to apply for both programs. The reason that's important is we had an individual who qualified for SSDI but really had no income coming in at all. We applied him for both programs. So then if you are asset qualified, so you have less than $2,000 worth of assets, SSI will pay you for that 5-month period of time. So what ends up happening is you get paid SSI, so that's $770 for that 5-month period of time. And then as long as your SSDI is over that $700, that then kicks in after the 5 months and you start getting that higher amount, and then SSI terminates. So it's important that people, if there's any way they think they could qualify for both programs, that they apply for both, because then they are going to have some income coming in during that period of time until their SSDI payment. Apparently the reason there's the 5-month waiting period is Congress, in their ultimate wisdom, thought that everybody has at least 5 months of income set aside, because we all do. So they thought that if people have paid into the system, I know, that if people have paid into the system, they certainly have 5 months worth of income, so we're not going to save money, we're not going to start paying until that 5 months. Go ahead.
So just to clarify, that 29 months, if someone's determined, is from the determination of disability?
Correct. From the date that they are found that they were disabled. Right, yes. There are, I think, 2 exceptions to that with the Medicare. One of them is kidney failure, and I think they just added Lou Gehrig's disease to that. So but those are the only 2 exceptions that I am aware of. As I said, the SSDI is basically based on a work history and have you worked enough credits. I can never figure out whether somebody's going to qualify. I can tell you if they haven't worked in 10 years, they're not going to qualify for SSDI. If it's any short of a period of that, then I always tell them to apply for it and let Social Security work out the work credits, because they're able to go through this person's work history and determine whether they've paid in enough or not. The other thing that we run into quite often is people that were self-employed or worked under the table, and they all of a sudden have all of these assets, so they're not going to qualify for SSI, but they haven't paid in and they don't have a work history, so they don't qualify for SSDI either. And I give, unfortunately, bad advice, I mean not bad advice, but bad news to people all the time who come to me and say, well, I was self-employed so I didn't pay in. They won't qualify for either program if they've got any assets saved up. So your question is, when you're doing functional capacity evaluations, what is it that they're looking for? What I often get as an attorney, and it's frustrating to me, is I will get letters from doctors that say this person can't work. Social Security doesn't care about the doctor's opinion about whether they can work. That is Social Security's job. What Social Security is looking for is what can they physically do. You know, when we're looking at a job, jobs for Social Security's benefit are in they go from very heavy, heavy, medium, light, sedentary. So what we're looking at as attorneys is, can they do things that are within the heavy? If they can, then they can work. And that's things as, can they lift 10 pounds frequently? Can they lift over 50 pounds? That's going to be heavy. How frequently, occasionally, or never is the way that they're looking at it. Yes, we want to know how what is wrong with them actually affects their ability to do things. Can they sit for a period of time without breaks? Because that's another thing that will make you disabled, is if you have to take unexpected breaks throughout the day for periods of time. If you can't sit, or you have to alternate sitting and standing, that is another one. A big one that we get with individuals who have heart disease are that they have to elevate their feet above heart level. That makes you unemployable. But the thing about disability is, and what I think doctors misunderstand at times, and my dad was a doctor, so I love doctors, but what doctors misunderstand is they believe that disability means you can't work at all, and that is actually not correct. You can work part-time and be on disability. And that gets me to the 5-step process. So this is the process that Social Security goes through to determine whether someone is disabled. The first step is, are they engaging in SGA, substantial gainful activity? And how they define that is, if they are making over, I can never remember the number because it changes every year, but it's about $1,000 a month, which is what I tell my clients. So if you are working and making over $1,000 a month, it doesn't matter if your illness is terminal, you are not disabled by law, and Social Security won't go on to the next steps. So when I have individuals that call me and they say, can I work a little bit? I always have to say, you know, obviously if you're able to work above SGA, you're not disabled. But if you need to and can work a couple hours here or there, as long as you're not above the SGA, then Social Security will look at it. The minute you go above that amount, that's where the analysis stops and they don't move on.
So I have a question.
Sure.
Mental illness, such as schizophrenia.
Yes.
How are these steps looked at differently? Or
They are not looked at differently. They're looked at the same. And I will, if I don't cover mental illness, because it isn't, when he's talking about a physical capacity, that's something that they can send in. It's the same thing for a mental capacity. So when I'm talking about things that are going to, what we're looking at is what are things that are going to keep somebody from coming to work. I do a lot of mental illness, Social Security disability, because private attorneys don't like to take them. They're tough to do. Usually there's a dual diagnosis with drugs and alcohol. So then it's the cart before the horse, which came first. But with anxiety, things like that, we have panic attacks where people will flee, which means they're going to have unexpected breaks. I will tell you that missing 2 or more days a month from work for any reason makes you unemployable, according to
2 or more days
a month, yes. Which sometimes people with significant depression or things like that. So there is a lot of stuff that goes with a mental illness that's a little bit quirky, but it's the same sort of thing. You know, it's chipping away at the ability to hold a job. So this, yeah, so SGA and these numbers have changed because they change every year. So non-blind, it's about 1,170. Blind, if an individual is blind, those numbers are always a little bit higher. So step 2, does the person have a severe impairment? And their definition is significantly limits the individual's ability to do basic work activities. I never run into trouble at this level. If somebody is coming to me, very rarely is Social Security going to say their impairment is not severe. Usually it's not severe enough, but they will find it to be a severe impairment. So usually if they're coming to me, it is because of the SGA and they get denied because of that. Actually, an interesting story, I had a cancer patient who I knew was terminal, and they denied her disability. And so I called the disability worker, and she did not have our appointment of rep on file, so she says, I can't tell you the specific reasons, but I will tell you that we denied her because of a non-medical reason, which to me immediately meant they denied her because of step 1. I knew she wasn't working, but what I found out because that worker told me that was that her fellow employees were donating their vacation time to her. So she was getting a check, and it appeared to Social Security that she was working. So we were able to get an affidavit from her employer that she was not working and that the check was basically a supplement from her fellow employees, and she was found disabled. So sometimes things like that, and that's why sometimes having an attorney involved that can go through the mental math of, okay, well, if that's what they're saying, then it has to be this step, is helpful. So number 3. So Social Security has this thing called the Blue Book, and it used to be an actual blue book, but now it's online. And it is a listing of impairments. And actually, if you Google Social Security listing of impairments, they have separate impairments for adults as they do children. But it will list out everything that if your patient meets those listings, that they will automatically be found disabled by Social Security. These are hard things to meet. So section 12 is mental health under Social Security. The first one is musculoskeletal, so being able to ambulate, et cetera. I'm not going to be able to tell you. I think 4 is cardiac. But there's 1 through, I think, 14. And they are the listing of, if you go through and your diagnosis is on there and you meet all of the things that are under that listing of impairment, then it stops there and you are found disabled. I will tell you the nice thing about collaborating with the hospitals is I have been able to, in the past, take medical records that I've received because my client is signed a release and email somebody over at the hospital. I have a doctor at one of the hospitals. I was able to email and say, the listing says this, your medical records say this. Are they the same thing? And she said yes, explained what the listing meant with regard to the medical records, and I was able to send that email in and get the person qualified for disability. So the collaboration is important for that reason, because I'm able to, sometimes what's in their listings and what are in the medical records may be the same thing, but I'm a lawyer, I don't know that for sure, and so being able to talk to the doctors and say, what does this mean, is very helpful. So that's number 3. Number 4 is, can they do their previous job? And that's the next thing they're going to look at is, okay, they don't meet a listing, but based on the things that they have wrong with them, can they do what they used to do? They were a mechanic, and so they had to do heavy lifting. They hurt their back. They have now huge back problems. They can't stand for significant periods of time. So no, they cannot do the work that they used to do. If they can, if Social Security finds that they can go back to the job they were doing, it's done. The last one is, can they do any other job in the national economy? I hate this step, and I'll tell you why. So this step is based on something called the Dictionary of Occupational Titles. It is something that, again, if you Google it, you can look it up. But Dictionary of Occupational Titles are jobs that it's supposed to have a qualification for every job in the United States. Here's the bad thing about those jobs. The Dictionary of Occupational Titles has not been updated in some cases since like the 1970s. So if you go in and you Google any job, go Google your job when you're done. Say Dictionary of Occupational Titles, whatever your job is, and Google that. You will see at the very bottom of it, it will say LMR, and that's going to be language, math, and reading, and that's the level that your job requires. It's going to be 1 through 4. 1 means it doesn't require very much, and then 4 is basically the hardest kind of jobs. And then at the very end of that trailer, it'll give an explanation for what your job is. Then it'll say what level of math, reading, and language that you need. And then the very end is going to be a year, but it'll be like 88, 77. Not the full year, but just that. That's the last time that job was updated to explain what it was. So I get people that say they can be an addresser, a mail sorter. I mean, that's the kind of jobs that they come up with because that, and people have taken up to the Supreme Court, and at this point, they have not changed, saying, nope, this is not, because it's the only thing that they have. So it's a little frustrating when people will say, well, so-and-so got disability and I didn't. If they can find any job in the national economy they think you can do, that is what they will say, and so you'll get denied. And mental health, again, is always a tough one because mental health is always very subjective because it is the person telling you. There are no physical diagnostics for mental health. If you have schizophrenia, you know, your symptoms that you're explaining to the doctor are going to be there, but unfortunately there isn't a test. Fibromyalgia is another really tough one because there aren't really any tests for that, and there's a lot of administrative law judges who don't believe that fibromyalgia is a real thing. So these are the steps that they go through. Most of the time when I'm getting somebody on disability, it's going to be a step 5 finding that I go through and explain to the court why it is that under step 5 they are disabled. I will tell you that I did do a step 3 one. This is my favorite case ever. So the guy applies for disability, he gets denied, it gets referred to us by one of the hospitals, and I get his medical records that are this thick, and I turn to page 3 and it says heart transplant. Okay, heart transplant meets a listing. So I find out from Social Security the reason that he was denied, he did not sign the one form that allows Social Security to get his medical records, and Social Security, instead of calling him and saying, dude, you did not sign this thing, we can't get your medical records, they just denied him. So here we had a gentleman who had a heart transplant, clearly qualified, but got denied. And so I sent the entire packet of medical records along with a little letter that says, guy meets listing number 4 point whatever, and he was found disabled. So sometimes it's ridiculous little things. But most of the things that I do are going to be a step 5 analysis as to why they're found disabled. So why do individuals get denied? Alleged onset date. And remember earlier I said the reason that you should have an attorney help you fill out this paperwork, that is one of the reasons you should have an attorney fill out the paperwork. One of the biggest reasons that we see that people get denied is they allege their wrong onset date. So the onset date is the day that you tell Social Security, I can't work anymore. That's the date they're going to look and start that 5-step process. Oftentimes, people will say, well, there's 2 things that happen. First, we'll have people, mental health patients especially, will file and file and file new applications and never appeal previous applications. So you'll have somebody that files an application in 2017, they get denied. In that application, they say, well, I became disabled as of January 1st of 2017 because I was hospitalized with a mental illness. They file that in January, they get denied, the denial happens in February, they then file again in March, and they say, go back to that same date and say, well, I was disabled as of January. They will get denied because that first decision and that first application is what we in the law call res judicata. It is final. That decision that they got, that they did not appeal, is a final decision, and they can't allege an onset date before that decision date. So oftentimes we have individuals who've never gotten help, so they file application, application, application. They keep alleging the same onset date. Social Security never tells them they have to switch their onset date. They will continue to get denied, and they'll never understand why it is they're being denied because all the paperwork says is you're not severe enough. Well, you're not severe enough because they're not going back to that particular date. That's one of the reasons. Another reason that we see is that people, you know, we were talking about people will feel crappy for months and months and months before they go to the doctor. They'll continue to work. But when you ask them, when did you first become unable to work, which is how Social Security asks the question. I was actually looking at an application this morning. Social Security will say in their application, when is the date that you became so sick you should not have been working? People will pick a date when they continued to work making SGA. Because in their minds, they should not have been working because they felt crappy, but they kept working. And so they were making over SGA. So again, Social Security will deny them because they will go to the first step and say, well, on January 1st of 2019, you were still making SGA, so you were not disabled, and we're going to deny you. So one of the biggest reasons that people get denied is they choose the wrong onset date. And it isn't labeled alleged onset date in the application. It says, when was the date that you thought that you became unable to work? And so people don't know how to pick that date, nor should they. The second reason that people get denied, they're not going to be sick long enough. The other thing with Social Security is you have to do 2 things in order to meet Social Security disability. One, you have to have a severe impairment that's going to last for 12 months or result in death. So somebody who is terminal with a disease, they are going to qualify for disability. your disability has to be disabling for 12 months. Now, what I get all the time is I get people who call me and say, but the doctor said that I have to be sick for 12 months and out of work before I can apply for disability. That is not a thing. You do not have to be out of work. You have to be sick or expected to be sick for 12 months. So if you get diagnosed with, say, lupus that suddenly you know has gotten to the point that you can no longer work, or something that you know is not going to go away, the fact that you haven't been sick for 12 months does not matter. All you have to be able to do is show that you're going to be sick and unable to work for a period of 12 months. Where I see this denial a lot is in oncology patients, because oncology patients, they always assume that they're going to get treatment, and within a 6-month period of time or whatever, all of a sudden they are going to be better. They don't take into account lymphedema and some of the other things, chemo brain, that sometimes will continue to keep people from being able to work. So cancer patients all the time get denied. When somebody calls me and they say, I've gotten a denial, and if I don't have the letter in front of me, I always tell them, read paragraph 3. So paragraph 3, because you get like an 8-page letter. Paragraph 3 is going to say, you told us you have this wrong with you. It's either then going to say, we do believe that you're disabled at this time, but we believe that you will get better within a period of 12 months. That's a durational denial. The other one says, we believe that you could adjust to other work. And that's a severity denial. They're saying, you're sick and you have a severe impairment, but it's not severe enough to keep you from either working your job or another job. So that's the only 2 reasons when people get a letter that I can figure out from that letter why it is specifically they got denied. And the third one, they do a really bad job filling out that application. So along with the application, they get a work history report that's going to explain the jobs that they did, and they're going to get a daily activities report that says, what do you do in your daily activities? And how I explain that to people, because they do a poor job, and it's a lot of paperwork for people to fill out. But they do a poor job of filling that out. So how I explain those 2 documents to them is the work report will say, these are the jobs that I did, and this is how I performed my job. The daily activities say, this is what I can do now. And I tell people, you need to fill those out, because what they do is they look at the work activities report, what were you doing before, what can you do now, and they compare them. And if what's in your daily activities is not what you used to do, so you were doing heavy lifting, and now you have to sit on your couch all day because you've thrown out your back and you have to lay down part of the day, then they're going to be able to say they can't do their previous work. And that's why they use those documents. But it is a lot of work that people get in order to fill it out. And so they do a poor job of filling that out because they feel crappy anyway, and they don't want to be filling out all the paperwork. So getting somebody to assist with that is very helpful. Okay, so I do want to switch into Medicaid a little bit. Does anybody want to ask me Social Security questions before I kind of get a little bit into Medicaid? Go ahead.
We were talking about what scale do you prefer to use it as Social Security even used for that when you talk about light sedentary and medium and heavy, because there's a lot of different scales out there, like the DOT scale or
So if you go into, Social Security has this thing called it's called POMS, and I can never remember what POMS stand for, but it's POMS. And POMS, if you go to, trying to think of what you look for under the POMS, it actually defines for you in the POMS, it's the operational manual that the individuals who ascertain whether somebody is disabled or not for Social Security, it's the operations manual that I think it's called the Procedural Operations Manual Systems, maybe. It actually gives a definition of there what they consider heavy, medium, etc. And I know that heavy is lifting at least 50 pounds. I always go through there. And then it talks about frequency of how often you can lift things. But it gives a specific definition of what they look at and how they define those things. I do want to go back for 1 minute to say that beyond the 5-step program, the other way that you can be found disabled, and I don't want to get too much into the weeds on this, another way that you can be found disabled under Social Security disability outside of that list of 5 steps is there's something called grids. So if you are a certain age and get down to a certain category, so if you are 55 or older, you're considered advanced age. And if you're advanced age, and the only work that you can do is sedentary, because apparently after 55 we can't train you to do anything else, And you really have had, if you've done unskilled work, so all you've done is you've worked as a hamburger flipper for McDonald's your whole life, and now you've done something where you can no longer do that. So if you're somebody who, like an attorney or somebody that really could learn a different job, the grids won't apply to you. But some of these individuals who really have very little education, have really done unskilled trades their whole lives, and now they're 55 or older, it's called gridding out. So you really just look across and you say this person is 55, they are illiterate, or they don't speak English, or they have only unskilled work, and now the most they can do is sedentary, which for the most part is going to be office work. You go across that and it actually will say at the end, disabled, not disabled. So a lot of times if we have individuals who are older individuals, I hate using that term, older individuals, the first thing we'll look at is do they meet the grids. The problem with the grids is mental health is not taken into account on those. It is all physical health, getting you down to, and the older you get, the higher up the scale. So at some point, you can't even, if you can only do light work, you're still considered disabled if you're a certain age. Okay, anything else on Social Security? Have I befuddled you enough about the... I mean, the thing that I want you to take away with Social Security is, when people are talking about why they were denied, you at least have the knowledge of, well, these are the steps they would have gone through, and we need to try to figure out under those steps which one they chose that you could still work at. It's almost always going to be, because if it's somebody that's going to meet the listings, that third step, Social Security is pretty good at catching those. So where people get denied is on the fourth and fifth step, and it's almost always going to be one of those two steps, and then trying to figure out why is it under those two steps, why can't you do your previous job. A lot of times my clients have not just one impairment. It's really easy when they have one impairment. One thing really bad that's wrong with them, but usually they have a combination of things. They have a bad back, and they have something wrong with their feet. They have type 2 diabetes, which is not disabling, but when you have neuropathy that goes with it, and you can't feel anything in either your hands or your feet, it gets difficult to do even sedentary work because you're required to grasp and feel. So it's those sorts of things then that can be referred over to us to look at the case and say, okay, and I tell people all the time, I sent a letter to a gentleman yesterday that I said, you have 0 chance of being found disabled. Based upon your medical records, which is what they look at, there is nothing in your medical records that's going to support a finding of disability. So we're very blunt about that.
We sometimes see people who are between 62 and their retirement age, taking early Social Security.
Yes.
And then get a diagnosis, say of cancer, and then want to apply for disability.
Right, and I'm glad you asked that question. So that, first of all, let's say that somebody, let's go to the age of 62. And let's say that somebody at 62 suddenly gets a diagnosis. And they will call our office, and we get this question frequently, shouldn't I just take early retirement? The answer is no, and I'll tell you why. If you take early retirement, you get a lower benefit for the rest of your life. I don't know why people don't understand. Social Security will try to push them to apply for early retirement because it's easier for them. But if they retire at 62, they will get a lower benefit for the rest of their life. If they are found disabled at 62, then they will get a disability amount, and then when they hit their regular retirement age, they will get their full retirement amount. So if you're found disabled somewhere prior to 67 or whatever your retirement amount is, and you can get disability, it will not affect your retirement amount once you retire. If you take retirement, it will for the rest of your life. The problem is individuals like that who take early retirement and then they're found disabled. You have to show that you were disabled prior to receiving your first check of early retirement. Once you've taken your early retirement, you're not going to be able to do a disability unless your disability happened prior to taking early retirement, which is really tough to prove. We've been able to do it. Right, because once you've taken the early retirement, your retirement is kicked in and you can't do anything about it. It's just you're on retirement. Because when you hit 67, they actually kick you off disability and you are just on retirement. So it makes sense, I suppose, that once you've taken early retirement, you're stuck with that. Unless you can show your diagnosis or something occurred prior to you taking your check. And that, usually people have come to us way far down the road, and it's a really hard thing to try and prove. Okay, so Medicaid. Medicaid eligibility all over the place. But I mean, the easy thing to know is if you have a patient who is poor and disabled, sending them to our office to try to do SSI. If they are found disabled under SSI, then they are automatically going to qualify for Medicaid, and we would send them to DHHS to apply for Medicaid. Otherwise, 65 and older is another one. If they are 65 or older, and back to the SSI, I mentioned 65 when I was talking about that. If you are 65 years old, or your retirement age, and your retirement is less than that $770. So say you've worked your whole life, but not enough where your retirement amount is actually going to be $400. You actually qualify automatically without a disability for SSI to supplement that extra amount. And most people don't know that. Most people don't know that if you were 65 or older, once you take your retirement, that you qualify for SSI automatically, whether you have a disability or not, as long as you're not getting retirement above that 770 amount. But with regard to Medicaid, 65 or older and poor, meeting their poor requirements, child under 19 years of age, the big one, of course, is having a disability according to SSI or SSDI. You can qualify for Medicaid while getting SSDI, the one that you paid into, as long as it is not over Medicaid's amount. And then you get into the share of costs, which I think is my next slide. So don't get it in your head that you have to be on SSI to qualify for Medicaid. That's the simple one. You can still qualify for Medicaid under, if you're receiving Social Security disability insurance, the money, how much you have that's coming in is what's going to make a difference. Okay, so if an individual's income is more than $900 a month, so he's getting SSDI, he can qualify for Medicaid, but with a share of cost. The other thing that people use as the same term is share of cost and spend down. And although Social Security oftentimes uses those as the same thing, I like to separate them out because they're a little bit easier to understand. So, share of cost. For some reason, Social Security has decided that this is $392, that's the amount, that is the magic amount for a share of cost. So to figure out somebody's share of cost, if they are making over the Medicaid amount, so if they're making over that $770 or the magic number to get Medicaid, whatever that happens to be, then Social Security is going to say, okay, we're going to give you Medicaid on a monthly basis, but first you have to obligate the difference between whatever you're making and $392 per month for medical bills, and then we'll cover the rest. That is a share of cost. So for oncology patients, people that are going to be treated all the time, every month, and they're going to have high bills, some of the hospitals, or my understanding is that they will pay that, they'll send that person a bill for the difference, and then Medicaid picks up the rest. So the person gets billed for, and $392, and this is $392 is for an individual and one other person, so two people. So even if there's two people in your household, the amount is $392. So if your income is $1,000 a month, I'm not going to do the math, but the difference is going to be whatever the difference is between $1,000 and $392, that's what you have to pay in medical bills every month in order for Medicaid to pay in. That is a share of cost. Spend down is a little bit different. So spend down, if you have, say, you have to spend down to whatever the Medicaid amount is. If you have an individual who's making, say, $1,000 a month, and say that they can make $800 a month and still be on Medicaid that particular year. If they're also on Medicare or any other insurance policy, if they have another insurance policy, that premium for that insurance policy gets taken dollar for dollar as a deduction from whatever their income is. So if you have somebody who's, say, $200 off per month, they can actually buy a supplemental policy of some sort that has a premium of $200 per month, and they will then qualify for Medicaid. And Medicaid would be the primary payer. The insurance, I think, is the supplemental payer, depending upon what. But they can do things, what we tell people is, because we have people who need like $50 insurance policies, and then all of a sudden they'll qualify. We tell them, go buy a policy for something that Medicaid sucks at paying for lack of a better term. Eyeglasses, dental, something like that. Buy a supplemental policy of that. All of a sudden they Medicaid qualify. So Another reason to send folks to our office when they have a Medicaid question is we can walk them through that. We can walk them through. They oftentimes don't like our answers because sometimes neither of them is a good answer. If there's somebody who only occasionally gets medical care, doing a share of cost every time you need to go to the doctor, they're basically paying for their own stuff. If it's somebody who's going to get ongoing care, then sometimes that share of cost is not a bad thing. If they are way over the Medicaid qualification amount, so some people get $1,400, $1,500 in SSDI payments, buying a supplemental policy to get down to that amount is not feasible. To give away $600 of your income per month to qualify for Medicaid is not feasible. So there is no easy answer, I guess is what I'm trying to tell you, between share of cost and spend down. If you send people to our office, we will explain what their options are. We will talk to them about what they're getting per month. Like I said, sometimes they tell us they don't like our answers, but at least they'll understand what their options are with regard to qualifying for Medicaid. The other thing is, Medicaid, you can have $4,000 in assets. As opposed to SSI, you can have $4,000 as a single person in assets for Medicaid. People give away their assets all the time thinking it will Medicaid qualify them, and what it does is disqualifies them for Medicaid for a penalty period. So the other thing is, if you send people over to the HELP Project, if you're one of the programs that collaborates with us, it gives us the ability to explain to them how to properly spend down what assets they may have to qualify for Medicaid. There's a lot of things that people will be denied Medicaid for that we can help with. The other thing that we have found is that individuals who are married but separated for long periods of time, Medicaid requires you to give the income information of your spouse. And a lot of times people will get denied Medicaid because they're unable to obtain that. We can assist with that. So if somebody is denied Medicaid and you think that it's something that they should be getting Medicaid, it's something that we can at least give advice on as to whether it's because it's an income thing or some other random thing that they really should be getting Medicaid, but they aren't for some reason. So Medicaid, and this is talking about the look-back period that I just kind of mentioned. Medicare doesn't pay for long-term care. Medicaid does. A lot of times what people are talking to us about is qualifying for long-term care to go into a facility, and that's where we see people get into trouble with giving assets away. They will sign their house over to their kids or do something of that nature that all of a sudden disqualifies them from Medicaid, and they're now unable to get into a facility because they're not Medicaid qualified. So the only thing I can say is if somebody has a bunch of assets and we're looking down the road for Medicaid, because Medicaid actually has a 5-year look-back period, so 60 months. So if you've suddenly given big gifts to your family and all of a sudden you need Medicaid, that big gift that you gave to your family members is going to count against you. And the way that the penalty works is, say I'm in a facility, I gave away a $100,000 house, and I'm in a facility that costs $10,000 a month. I'm disqualified from receiving Medicaid for 10 months to equal the amount of what they would have paid out and what that asset was. So I have that 10-month disqualification period where I either have to pay out of pocket or I'm not going to qualify before I can get on Medicaid. So it's not a forever thing, but it is pretty big depending upon how much you've given away.
So what about people who do reverse mortgages?
So I don't know how the reverse mortgage thing works actually with regard to Medicaid, because they haven't necessarily given away their house. It's a reverse mortgage where they're receiving money on it, and that question I can't answer because I don't really deal with the reverse mortgages to know.
On the screen before this one,
Yes. Is that it, or did I go forward?
you went, yeah.
There we go.
The bottom example.
Yes.
This is an example. If I'm reading this right, so they basically want people to live on $392 a month.
And again, when I was talking about the DOT, so the Dictionary of Occupational Titles that hasn't been updated since the 1970s, I'm pretty sure that that amount hasn't been either. I don't know where that amount came from. I've never been able to track down where they got that amount, but yes, that is the amount that, and that's why if you have somebody who can do we actually have an insurance agent that I ran into at one point that does a great job of helping people with supplemental policies if that's something. But you have somebody like that, they would have to do about a $600 policy in order to qualify for Medicaid. Yeah, and that's why I said people often don't like my answers because they're cruddy answers, but they're not my answers, they're the legal answers. Yeah, yeah, I wish I had a better answer for that. But Medicaid obviously can be really tough to get into. I only have a couple of minutes. Spousal impoverishment. I don't know if you guys deal with this on a regular basis or not, though spousal impoverishment is another way that Medicaid can work for individuals that are going to be in long-term care. The term means that you have an individual who needs to go, so you have a married couple who have a lot of assets, and one of them needs to go into a long-term care facility and is not going to return from that long-term care facility. So you have what's called a community spouse, or the spouse that's still out living in their house, and then you have the individual that is in the nursing facility. So you want the person in the nursing facility to qualify for Medicaid, but you don't want to drain all the assets. And the horrible thing that happens all the time is that people don't talk to lawyers and they spend down all of their assets thinking that that's what they need to do to qualify the person that's in the nursing home for Medicaid, and that is not true. Spousal impoverishment allows DHHS, the Department of Health and Human Services, takes a snapshot of what the couple's assets are. The house does not count as an asset if the communal spouse is going to continue to live there. So they take the rest of those assets, they divide them in two. The community spouse gets to keep up to, the last number that I remember was like $119,000 worth of assets, not including the house. That are the assets that community spouse gets to keep. The other half of the assets that are divided out to the spouse that's going to be in the nursing home, that's what has to be spent down. So it's half of the couple's assets, not including the house. So usually there isn't a very large amount that spouse that's in the facility has to spend down. That money can be used to fix up the house. There's a lot of things that can be spent down on, so that then that person that is in the nursing facility can qualify for Medicaid to stay in the facility. In addition to the asset separation, the community spouse is entitled to a certain amount of income coming in per month. So say that the person who's the community spouse has a very low retirement and the person that's in the facility has a higher retirement amount. Some of his or her money can go to the community spouse every month to get them up to that amount, and then the rest would go to the facility and Medicaid would pick up the rest. So this is something that a lot of people do not know about. They unfortunately will end up spending down all of their assets, not understanding that this was something that they can do to keep the community spouse out in the community. Obviously then if the community spouse at some point wants to go into a facility, then you have to deal with that house and everything else. But I'm just talking about if you've got one spouse who is going into the facility. And this is something that we can walk people through at our office, the explanation of spousal impoverishment and how it works. I just spent half an hour on the phone the other day explaining it to someone who thought he had to give away all of his parents' assets, or spend them all down in order to get his dad into a facility. So that is it. I always think I'm going to talk too short and then we hit our time. But anything else I can answer for you guys?
For the spend down stuff, does Medicaid care have an order you spend it down? I always have families ask me that, if the thing spending stuff on the house versus do we need to be spending it on their care?
No,
Does it matter?
they don't care. As long as it is spent in one of those appropriate ways, they don't care how it's spent on.
Pay your bills off first.
Right.
Do all that first.
But we go down rabbit holes all the time with folks because they will cash out their retirement. They will use the retirement on something that's appropriate, but then all of a sudden they have to apply for Medicaid, and Medicaid says, where'd that money go? And so we've had to try to go figure out exactly where all of that money was spent. And then usually if we get to a reasonable dollar amount that's left over, we can do an affidavit with the client saying this was used for necessaries of life. And we've never had Medicaid give us a problem with that if we can find the large amount. We had one that was $27,000 and they bought a car. They kind of went through all these things, and I think there was like $1,500 left over that we couldn't figure out. We did an affidavit. This was spent on rent, mortgage, et cetera, and got them Medicaid qualified. So that is the tough part, when they cash out before they get to us. And they do spend it on appropriate stuff, but nobody ever keeps receipts.
Nebraska Medicaid expansion is that they don't have to have a dependent in the house anymore, is that right?
That is correct. I'm not sure when that's going to go into effect. I think there's probably going to be litigation. Oh, the question was Medicaid expansion in Nebraska, whether that means that they no longer have to have a dependent in the house. What it really did was it raised the income limit, though, as well. So you don't have to have a dependent house, and it raised the income limit. Under the Affordable Care Act, there's individuals that, there's the Medicaid qualified individuals, and then there's the individuals who get the supplement to pay for their insurance under the marketplace. Where you had that gap of folks was the folks that didn't qualify. They made too much to qualify for Medicaid, but too little to qualify for that supplement, because when the ACA was put into place, they assumed every state was going to expand. So you had that big gap of folks. Medicaid expansion is meant to cover that gap of folks up to the point that they can get a supplement to pay for insurance. I think there's going to be some litigation and some other problems before. I guess I'll be surprised if it goes in cleanly. But stay tuned.
Thank you.
Oh, you're welcome. Always happy. Always happy to be here.